and feeling that the law suggests that sympathy should be considered, and a compromise verdict is nothing but sympathy. This should not be a compromise verdict. Whatever their decision should be, it should be an affirmative, just decision based upon the facts. I don't want them doing a jury pardon, which would let my client off because they feel sorry for him, and I don't want them doing a compromise verdict because they feel sorry for anybody else. We've done a very, very strong job of making sure that this jury gets evidence that they should get, they don't get evidence that they shouldn't get, and that they're going to follow the law and apply the law, and I don't want compromise verdicts or jury pardons.
Well, given the fact that Zimmerman was on the fence about testifying, does that give some kind of indication that he may not have been as confident that the case was strong enough?
No, I think he was confident in his desire to talk to his jury, but I don't think there was a lack of confidence in the way the case was presented.
Mr. Mayor, can you clarify potentially what lessers will go to the jury?
Well, my understanding is that manslaughter is what we call a category 1 lesser. Aggravated assault may be another one that they consider. I don't think it's factually appropriate at all, but we'll talk about that tomorrow with the judge. And I think those are probably the only ones that would be considered.
Are those both with and without? I mean, is there like a manslaughter with a gun?
Yes.
Aggravated assault with a gun?
That's correct. Those are all variables.
Have mandatory minimum?
Yes, they do.
Mark, just to clarify on the THC levels by Trayvon Martin, that will not be in any way accessible to the jury?
That is correct.
Not even in the autopsy report?
Of course not. No, it's not part of the evidence.
What would have been the downside for the defense to bring in the marijuana evidence?
Well, again, it's hard to say to take that one string out of a complete defense strategy and say, okay, let's look at this string by itself, as though you really want to know what the tapestry looks like. But if you really want me to take that string out, it didn't seem to be significant enough intoxication evidence that it was worthwhile making the focus on that, because I am concerned about the jury's sensitivities. So, you know, whatever we do is always taking into consideration how the jury is going to view what we present. That, of course, impacted things like having to call Tracy Martin and other people to the stand. You got to look at that and weigh the positives and the negatives with any presentation of evidence, and that was one of the decisions we made.
Was it your intention all along, you know, strategy can change from day to day. Was it your intention all along to begin with George's mother and finish with his father?
No.
Did you plan to get on that dummy this morning, or was that an impromptu thing?
The doll? No, that was impromptu. You know, sometimes those things come over you.
The state has perhaps withheld discovery or committed some misconduct and should be sanctioned. Looking back now at the trial that you've rested, where, if any place, did their actions hamper you, in your opinion?
You know, in a lot of ways, I could say easily, I'm still frustrated that some of the phone evidence we got so late that we weren't able to do some of the background work that may have otherwise made it more admissible. So that's a point of frustration, particularly. We scrapped through it, you know. We took what we got and we kept fighting until we got what we thought we needed. There's more that I wish I would have had, but I think within that context, we still were able to put on a pretty decent case.
Mark, just remind me, in a case like this, when the judge goes to charge the jury, the typical amount of time that takes to read all that paperwork for them?
Actually, reading the instructions seems like forever when you're listening to it, but it probably is a solid 10 or 12 minutes. That's about it. And of course, in Florida, we're allowed to have a copy of the jury instructions go back with the jury. So I started in the days when you just heard it once and then went and tried to remember it. So at least now they'll have it with them.
Mr. Mark, we've been told by both former prosecutors and defense lawyers that if either side requests the lesser included, the judge basically has to include them. Is that your understanding? What makes you think that they may not get, you know, how could you possibly block them?
Category 1s are sort of mandatory upon request. However, the judge still needs to make a determination that there's a factual basis to support it. You could not, for example, ask for a fact or a charge that is not based in any consideration of the fact. Right now, they couldn't go in and ask that the jury be charged on possession of marijuana by George because there's no facts to support it. I think that they are in the state's position that they believe there may be facts to support their lessers. I don't think there are.
You said about if you go back to the jury, the lessers, what's the sentencing range?
Well, the sentencing range is anywhere from life imprisonment to he'll walk out a free man.
What about on the manslaughter charges? We're not sure what kind of penalty George would face should this jury come back with a manslaughter conviction.
You could face up to 30 years upon one consideration of how they may charge.
And Mark, the jury won't know what the sentencing guidelines are when they consider the charges, will they?
No, that's one not problem for defense attorneys, but the concern is that under Florida law, we can't advise them as to the penalties. That's up to the judge. Having said that, someone may look at a second-degree murder charge and say, okay, I know that's serious, but maybe they think manslaughter is not. I really do believe that this jury has been listening attentively. I think that they're going to listen well to the instructions, and they seem very intuitive. So they're going to look at the law, apply the facts to the law, and make their decision. I don't think we need to worry about considerations of sentencing, jury pardons, or anything like that.
So the judge still can do it, she can still tell them, she can, it's up to her discretion to tell them the sentencing for a manslaughter?
Oh, no, she
Or
will
they
not.
accept that?
No. They will not be, nothing will be mentioned about sentencing to this jury.
Mr. Omara, what will it mean to your client to have his parents in the courtroom finally for the closing? That would be
Very emotional, yeah.
What is George's plan as a piece of conduct, and does he think he would still be a pariah, and will his life actually be changed by an acquittal?
I think that he's very worried about his safety, personal safety going forward, because those same people who portended the fear and hatred leading up to this trial probably are not going to accept an acquittal, though they should, since the system's working, but, we can't.
No one got Casey.
Glad to hear that.
Will he make a public statement if acquitted?
I haven't made that decision yet.
Could you talk about
interrupting the judge as she tried to directly ask George Zimmerman if he understood his rights about testifying?
I think that was just a question of semantics or words. It always needs to be couched in terms of the defendant's conversations with counsel. And I think it was really just a momentary semantics issue more than, it definitely wasn't substantive. You could tell from the fact that he came back in a few minutes later and acknowledged. Okay.
Could you talk about the neighbor who talked about her house being broken into by two black males? You didn't go so far as to say, does that, you didn't really mention Trayvon Martin and connecting them particularly, but what was that testimony about, and how did that help your case?
Well, you may not have been aware of this because there was a stipulation, but the last year's worth of burglary and other information that happened in Retreat View Circle is now of evidence. It was by stipulation, so you didn't hear about it. But the jury has to consider the last year's worth of alarms going off, burglaries and whatnot, so they know the context of why George was calling. And she was one of the most recent victims of the, and quite honestly, one of the most horrific victims of a home invasion where she's got to hide in the corner of a bedroom with her 4-month-old in her hand. And I thought that was necessary to present to this jury.
What happened to the hearing about the restraining orders and the assault on police?
The hearing on what?
About letting that in.
Oh no, the state was considering something like that for rebuttal and decided not to. So that never needed to be ruled on by the court.
There were mentions of threats of rape to Don Wett's daughters. We were wondering if you were afraid for your safety or the family was as well.
We've been very cautious throughout this whole thing, and there are ebbs and flows of people's animosities that show up. Certainly last week, when that was perceived to be some at least racially insensitive event, there was an upswell of that, but I think that's receded. Obviously, it wasn't a racially motivated event. Actually, a picture was taken 2 days before Ms. Gentile even testified, and I think that was all cleared up. But we're going to be cautious into the future. I think that there will be some people who are angry with an acquittal, and we'll work through it. And hopefully, they'll be at least willing to talk.
Were you surprised that the prosecution ended up with so few rebuttal witnesses and asked for so few to begin with?
Well, their rebuttal is directly connected to what we present. What we presented was a lot of voice witnesses, and I don't think they had many voice witnesses to act in rebuttal. And we presented a couple of experts who talked about use of